go ahead and get started then? Well, hello everyone. Can y'all hear me? Yeah, you can. Great. Um, all right. Hello everyone. Welcome and good afternoon. Thanks for joining. I'm recording this for those of you, for those of us who could not attend. I'm going to record it for their benefit. Um, Hopefully today's CLE will be helpful and educational for you. We're still waiting on a few people, so I'll let them file in. The CLE code will be posted at the end of the presentation. So for those of you who don't know me, my name is Furkan Saniyazar. I'm a founding member of the legal committee board member. I'm a founding legal committee board member of MLFA. Been a board member for, I guess, close to 10 years now. I practice immigration law in Allen. We also have an office in Oklahoma City. With me today is Kate Brady, MLFA's immigration department head, and Frankie Daniel, our senior staff attorney, also in the immigration department. Both brilliant attorneys, and all the credit goes to them for their hard work for today's presentation. Thanks to DFW MBA for hosting us in the CLE. So just by way of background, DFW MBA is a non-denominational, non-political union of lawyers and law students of Muslim faith, open to lawyers and students of all faith traditions. They seek members who wish to serve and protect the constitutional rights of all Americans, with a special focus on minority and American Muslim communities. They align together to give back through community service and pro bono legal work, and to promulgate legal information as a tool for social empowerment. And let me tell you a little bit about MLFA. It's a community-centric grassroots nonprofit organization fighting for national security reform, upholding and establishing justice in our courtrooms and communities for Muslims in America. MLFA is addressing unwarranted actions towards Muslims, such as travel restrictions, immigration denials, bank account closures, extra scrutiny of nonprofit work, prisoners denied religious accommodations, and unjust prosecutions and unfair trials. All right, so let's get right into it. Today's presentation will focus on the intersection of U.S. immigration and national security laws, particularly as it relates to the targeting of Muslims. The government uses surveillance as a tool to assess potential security risks, but unfortunately, it also disproportionately targets Muslim communities, impacting their privacy and civil liberties. As some of you may know, over 95% of those on the FBI's watch list are Muslims. Yet there is not a shred of credible evidence that the unconstitutional watch listing of American Muslims has made America even the slightest bit safer. Muslim men often face additional scrutiny due to stereotypes and misconceptions, exacerbating the challenge they encounter within the immigration process and societal perceptions. And Muslim women experience heightened anxiety. Balancing security measures with protecting individual rights remains a complex and ongoing challenge for policymakers. Next slide, Peggy. Yeah. So I want you guys to take a look at this graph here. I think it's really interesting because you'll notice that there's a huge decline after 1917. What occurred here is that the 1924 National Origins Act was the immigration restrictionist hope to achieve the preservation of whiteness through the immigration system. The 1950s McCarran Report defended the National Origin Act as a system of allocating quotas as the best way to preserve the sociological and cultural balance of the United States. Things changed in 1965 with the Civil Rights Movement and the rejection of the national quota system, which helped lay the groundwork for reform. So what do I mean by the preference system? It was replaced by the preference system, and the preference system basically means that the new immigration system was going to focus on preferences based on family members. So, for example, if you are the spouse, parent, or child of a U.S. citizen, you're considered an immediate relative. And so the United States places a higher preference on those sorts of relationships. And so that replaced the previous quota system. And so a majority of the visas were set aside for family members, not necessarily immediate relatives, but also married children, unmarried children. If you're a permanent resident, you can sponsor your spouse or child. And then they also allocated visas towards workers and refugees. So with that, I'm going to pass it over to Kate, who's going to take over the rest of the presentation along with.
So as I've been practicing immigration law, I have definitely experienced a lot of the policies of government agencies and how they restrict immigration. But normally in those private immigration firms, not at MLFA, we saw those as restricting people just basically from certain countries or certain regions of the world. But here, we've noticed that there is definitely a way that the government has used national security to justify a specific discrimination against Muslims. And it kind of reminds me of the quote by Benjamin Franklin that those who are willing to give up essential liberty to purchase a little temporary safety deserve neither liberty nor safety. And this has been ongoing for many decades, but it kind of heightened after 9/11. So if you were around in the US and knew anybody who was in the immigration system in the early 2000s, they had a registration system. And of course, the government loves acronyms. So NSEERS, and it made people actually responsible as individuals who are non-citizens to check in with the government. And it was to keep track of them. It was basically designed to look at Muslim males mostly. And for those who were not in compliance, they could be arrested, detained, they could lose benefits. And the issue here was that it really was a targeted effort. And luckily, it was not long before that was found to be unconstitutional and did not actually continue. But what we have noticed is that they just switch their tactics. So there are new ways that they have done this. But if you look at who got addressed here, it was those individuals who were age 16 or over from a certain set of 25 countries. And these are the countries. And if you look at it, you can see that it is not for those of us who practice in any type of area that intersects with immigrants, a normal map. This map is definitely targeted. And if you think about it, the countries that were targeted here, other than maybe the outlier of North Korea, are very similar to what we saw in President Trump's Muslim ban. So let's look at that. So next slide. The Muslim ban, people who were outside of the area that was really being impacted would call this a presidential proclamation or a travel ban, and would say that it was really for security, and the government tried to justify it in a lot of different ways. But until they kind of narrowed down their justification to the vetting capabilities of the countries, they kept getting challenged in court until it actually passed muster. But some of the things were pretty incredible. I mean, it banned all refugees from Syria, all of them, and did not allow individuals from all of these countries that are very similar to what was done in the NSEERS registration to come to the US unless they had some very narrow exceptions, a lot of which were related to kind of the preference categories that Sunny was talking about. And the only way that it really got through these constitutional challenges was that they started adding other countries, like, Venezuela and North Korea. Those kind of, I guess, gave it a little bit of street cred. But eventually, when the administrations changed on January 20th, the first day of President Biden's term, he rescinded those restrictions in another presidential proclamation. This was a great tool for Trump and his restrictionist government, and it's one that was very visible, but I would say that it really brought to the forefront things that were happening in the background in the immigration world, at least. Next slide. I'm going to pass it on over to Frankie for a couple of slides here.
Okay, so like, what does all of that mean to us today? What does this look like now? What we know is DHS, Department of State, other governmental agencies, they look at your associations and affiliations that you have anytime they're reviewing an application. And so what we have seen is DHS commonly will look at certain associations, organizations, and they will have negative connotations with them, regardless of what they are. This can be whether it's a cultural organization, it could be a social association, even educational and other religious things, things that shouldn't be an issue. And I would ask you guys, what are some that you have seen that have been like heavily scrutinized on applications that you've worked with? I can tell you that when we're talking about how they target the Muslim community, oftentimes organizations like Maya, even gets targeted, or they heavily scrutinize it when it shouldn't be, but that's what happens oftentimes. And so knowing that they're going to nitpick certain organizations, we want to kind of talk about like, okay, so what does that mean? I would say, free speech pitfalls. We talk about like what you say matters. And while you're free to say things, you have the freedom of speech. DHS will target protected political speech if they believe that intersects with or falls under TRIG or terrorism related grounds of inadmissibility. While you have the right to say certain things, if you have immigration applications pending, it could have negative impacts. It could cause delay. It could cause extra scrutiny, and they would say additional administrative processing, right? Because they're going to look at that differently. They have extraordinarily broad criteria that they're looking at for this. And so while it may otherwise be protected, it can still trigger for the government additional scrutiny and screening of your application as you're going through that immigration process. So I'm gonna hand it back to Kate for this next slide.
Can you hear me okay?
Yeah.
Yes, we can hear you, Sunny.
I'm just curious, like how much delay are we talking about here? Are we talking about like a couple of weeks, a couple of months? We're talking about a year? Like what are you saying? Like what's the average delay? What's the worst delay you've ever seen?
I would say as far as, I'll give you a spectrum. It could be months. We have seen years. We have cases. Yes, we have a case currently that has been pending for over 20 years. And it is definitely going to fall within this, as I said, I don't know if I gave you the acronym for CARP, but that's
that CARP like twice your size.
I'm sorry, I didn't quite catch that.
That was background.
Oh, okay. So CARP is the Controlled Application Review and Resolution Program. And so basically this is an extended program that the government uses. It's an administrative processing tool. We would say unconstitutional, but they use this tool to put applications through significant additional screening. And really it's like a black hole. They say it's additional screening. It's really sort of we're just going to sit it over here and it's going to wait until somebody causes a ruckus about it. And then we'll come back and we'll do a little more work on it. But those cases can go for, like we said, decades. Kate, did you have anything you wanted to add there?
I guess I would only say that it was a little complicated by the travel bans and CARP and the last administration. So the ones that I would see kind of on average 3 to 4 years, maybe 5 years. But again, we do have one that was kind of in the computer black hole, as they told us later at USCIS, that is now approaching, let's see, it's 22nd year. It's about 21 and a half years right now. So not great. But one of the sections of the USC that most immigration attorneys have never had to intersect with is the one under the security related grounds of inadmissibility, or as we narrow it down, the terrorism related inadmissibility grounds, because security related can be other things related to crimes and drugs and fraud and things like that. But this is really narrowing it down to the ones that are in the security related, terrorism related grounds of inadmissibility. And the way the government has kind of striated these, they look at 3 different ways of doing that. And there are organizations, and they're the ones that are kind of obvious, that are designated by the Secretary of State. And a lot of those are also designated by Treasury for restrictions on finances. Those are the tier 1. And then there's another one that is designated, so that's Secretary of State. So then there's another set of organizations that are designated by the Attorney General or the Secretary of Homeland Security. So kind of like a little bit lower level. And then the third one is the one that is the bane of my existence and my white whale. And if this would go away, I would think it is a great victory for immigration attorneys everywhere. They're tier 3, undesignated groups of 2 or more individuals, whether organized or not, which engages in or has a subgroup that engages in terrorist activities. So this is literally, in my opinion, like when the Supreme Court said that they couldn't define pornography, but they would know it when they see it. Because when you look at the USCIS guidelines, it says it's on a case-by-case basis, and that they will look at the facts of the situation. But really what this is it's like profiling the 2 guys walking down the street in, I don't know, I'm from the 80s, members only jackets, so are they a gang? So that's really what it is. And these are people who have done things as simply as donated to organizations that then are considered unfavorable, that have maybe spoken at an event or things like that, where later on the government says, we just don't feel really great about it. Like we actually have had cases that fought on the side of the United States government. And then when it came down to it, the government then says those people committed terrorist activities because they worked against the government that we were working against. Really, like in Afghanistan, we're working against the Taliban and the Russians. And we've had cases where they've denied them for that actual activity. So it's elusive and slippery, and every officer can kind of spin it how they want. And this is really where those group associations have been the most problematic for our cases. A subsection of this is the material support of the tier 3. So material support is also very vague, very broad. And so it's not like you can just say to people, oh, wow, yeah, like they still have a Nazi question on the citizenship application, right? So it's not like you can just say, oh, yeah, you were a Nazi prison guard. Obviously, you're going to be inadmissible. These are things as innocuous as maybe the organization that is now disfavored or designated, not undesignated, demanded that they get to stay in your house. And, there's very little leeway for things like duress or insignificant support. And it's a frustration that people are in these really like high pressure situations that those groups have control over, and that regular citizens are really punished for living under those conditions. But as I said, generally speaking, I've only seen it applied to Muslim countries. You don't see that in any other countries that have had physical altercations or criminal unrest or governments fighting against each other. I mean, you can just even look at the difference between the way that the government welcomed people from Ukraine, like almost immediately after Russia invaded, versus the long drawn out process to demand those same benefits for people who were evacuated by our own government from Afghanistan. So, and as we talked about earlier, even in some instances that can be speech. So that's if, and speech is really broad. And we have a lot of things on our website that talk about that from the civil department. I mean, it's liking things on Facebook, forwarding on Instagram, videos or TikToks or things like that. Those are considered speech. And even though it is protected against criminal prosecution, DHS, DOS, they don't work in that realm. They just have to have a reason to believe that you're supporting and even in this low-level slippery materials support of a tier 3. So it's extremely frustrating, and it's so obvious to those of us who work in it every day that this is a targeted religious discrimination, which is really what we try and drive a wedge against the government for. All right, next one. I believe this is going to be Frankie.
This is me. So like, as we mentioned earlier, like, why does this matter? Because on all those applications, they're going to look at it. And so a security investigation is a part of any immigration application, and they're going to take into account those social media accounts and what you've posted, what you've shared, what you've commented if they see it. And so, yes, we want you to be truthful. We want you to give accurate information as best possible. Excuse me. But keep in mind that, like I said earlier, although you may be free to say certain things, what you say can come back up later in the immigration application process. And unfortunately, we've seen that there is a bias and that they're going to mislabel protected speech, and they're going to heavily scrutinize it and twist that information and use it sometimes to deny immigration benefits. And so you want to be mindful of that as you're going through the immigration process, that this is out there, and that the government is sneaky. And it's not just going to be a matter of what you posted. They're going to go out and they're going to look and they're going to check your account and your friends' accounts and see what information comes up. I think Kate has something she wants to add here.
Yeah, I was just going to say that the fun part about this fun is that, like, even asking you to provide truthful answers to immigration and Department of State, they're sneaky about it in a way where they don't really deny you necessarily for that association or what you've said, but if you lie about it, that's where they're going to get you. And that's the same thing our criminal department will say a lot about. The most criminal prosecutions under the terrorism enhancement statutes are for lying to the FBI. So you will get your application denied for things like material misrepresentation or fraud, or even lack of good moral character based on material misrepresentation and fraud, before they will actually try and prove that you supported terrorism.
Absolutely. That is definitely what we see the vast majority of the time is in the denials. It's not that they're saying you materially support it. It's saying they lied about something that they would then later think was that, but it's the failure to disclose it is what they're putting in the application or in their denial. So absolutely, that's the crux. I would say the old adage of the cover up or the lie is worse than the act. That's what we're seeing here for sure. Okay. So I mentioned CARP earlier. What does that look like? So this slide here really kind of gives you some examples of behaviors and things that you might see from the government that's suspicious, right? Is this targeting? Is this CARP? Is this an issue? Or is it a legitimate processing? Is it a legitimate investigation into some of the information in the application? So like when you have these processing times that are ridiculously long, you kind of have to go back. Was this during COVID? Was this when things were closed? Is there a reason for this long delay? Or are they saying it's a long wait and it's the security clearance for a visa application and everything else has been supplied, everything else is good, and there are no, I would say, suspicious associations that you would expect them to want to delve a little deeper into. Sometimes there's administrative processing for months, even years, like I mentioned earlier. One that we've seen, I would say more recently, is this: either their interview is not being scheduled, or the next one it's scheduled, but then you show up and they're canceling it and not rescheduling it. Those are suspicious behaviors that I would say that looks more like CARP than just normal processing. If you're waiting till day of you show up and then they say, no, we're not going to do the interview today. Oh, that officer isn't in the office today. Those are things that start to look more like there's a CARP issue here and they have sort of put your case into this additional processing. Again, no decision after the interview, and it's well past 180 days, well past a year. They have these time frames. We tend to let them really give them a lot of rope. So even though we would tend to think 180 days, that's what it says on certain things, we give them a full extra 180 days before we even start saying, hey, you're really past time here. And then this other one here that we have towards the bottom, the extreme denials for false statements. That's what we were mentioning before. It's like they're wanting to deny the case, the application for something else, but they'll find something small. Oh, you didn't list this traffic ticket, and we're going to say you lied about it because you said no citations. That may be true. They have other concerns. This is a CARP situation. They're trying to find something else. There, Kate, do you have anything before I go to the next slide?
I think one thing that we've also seen that maybe we're highlighting here is people who were asked to be confidential informants for the FBI and refused. Yes. So that is also one of the hooks that seems to pull people into this process that is not necessarily their behavior that is suspicious, but it's a retaliatory behavior.
When you
when
you guys encounter CARP cases, are your cases circumstantial, or do you ever find smoking guns?
I would say we do a lot of pre-work before we agree to accept a case that we think is discrimination. So if we look at what they've given us, or if we do a Freedom of Information Act request and see the background of the case is not quite what we were told, which, clients don't always give you all the information, right? So yeah, we have seen some smoking guns that are somewhat related to maybe organizations or things that they didn't disclose. We have had, a couple of them that, like Palestinians who've maybe been arrested by the IDF and questioned and rock throwing type of stuff. But for the most part, if I turn down a case that might have that component to it, it's because they also have something really bad, like a criminal conviction or something that is a legitimate reason to deny it. Even if I could argue the fraud, we'd still lose. So, but yeah, we've seen some definite ones. Honestly, I think I had one that was, he gave us very little information, but when I Google searched his name, I came up with a very serious plot against a political person in the US in the 1980s. So yeah, that was a pretty big smoking gun. Actually, I think this is me again. So this is just a way that I like to give people kind of the balance of whether or not, when you're looking at a case in the immigration realm, whether it is discrimination or whether this is just the fact that we have a terrible immigration process.
Yeah.
And this is one that kind of hits on the preference categories that Sunny was talking about at the beginning. An F4 category of a visa is one of those preference categories. It's for a sibling of a United States citizen, and there is very few visas allocated to that category. So it will take decades for this. So that is something where you really can't say, hey, my friend who was in a different preference category, or what we call an immediate relative, which is one that is an unlimited category of spouse of a U.S. citizen, child under 21 of a U.S. citizen, or a parent of a U.S. citizen. Those cases you cannot compare. These are not apples to apples. So what you want to look at is other siblings from your same region, because there's also some country limitations, right? But if everything has been provided, if it's not a consulate that's closed, because we're dealing with a lot of consulates in the Middle East that are periodically closing for civil unrest. Like we spoke with somebody recently where her case was assigned to Beirut, which is closed now. Those are ones where if you are not moving through the process and there's no interview, or you're being placed in administrative processing, that's when where you're maybe looking at, this is not necessarily just an inefficiency. This is a targeted situation for them. And what they love these little like general explanations. They used to do a lot like your security clearance hasn't been done yet. Now we see like an officer's reviewing your case, but they need additional time. There are just these really vague, squishy reasons that when you see it over and over again for cases, you realize that they aren't even telling you anything about this case. This is just what the button they were told to push. If, you know, when a person asks the question, if you see this on the screen, push this button and it'll give them the vague answer. So if people are inquiring about, do you think my case has a problem? This is part of our balance that we have to do. But Frankie's going to tell you about some of our cases, and I'll probably chime in a little bit about ones that were really not what you would think at first blush, and the government really should not have even tried to get away with what they did. So I'm going to pass it on, but I'll see.
My mute button was being difficult. Sorry about that.
Go one slide back.
Yep, I see it. That's because my cursor was being difficult. That's where my mute button go. Okay, so these are just some examples of cases that we have handled personally at MLFA. This first one here with the imam. There's a question on the citizenship application that asks whether or not you've ever received weapons training. And typically that's a pretty straightforward question. You think, no, I've never been in the military. I didn't have to do my required training because I left before I was of that age, all these different things. Well, in this instance, the government wanted to say, yes, actually you did receive weapons training, because in the 8th grade, you had a lesson, a training on using a wooden replica of a firearm. And this was in the 8th grade. So again, think back to how old you are at that time. And they're saying, yes, sir, you received weapons training, not just there was a discussion in a class at a school. So that's the type of I would say egregious. They're really reaching issues where they're trying to pull you in on some of these specific things on applications. Another one we had where, so this person, religiously educated, son of an imam, his application was denied basically for pretext things. In his application process, he talked about where his children were born and where he was at that time, and the government was wanting to place him in a specific place. And so because this person had multiple children and these children were born many years ago, remembering that child was born in this city, and it's not like here in the US where it's like everything is marked, and you know, like this specific hospital is at this place and it's been there and it's not moving. And children are born in hospitals most of the time, not in clinics, not at homes. And so you're trying to remember exactly where that birth was. The government used his imprecise but accurate information, his accurate answer, to try and say, no, I think the reason that you're being squishy on that answer is because you were actually here in this location, and that's why you don't want to tell us where your child was born. That type of stuff where you're not allowed to have vague memories, which everybody has, but the government looks at it as in this instance, I'm sorry, I didn't mean to go back a slide. The government wanted to look at it in that instance of, oh, if you're that uncertain of where your child was born, clearly you're just lying. And then the last one, Kate sort of mentioned the confidential informant. This is one that anytime we talk about this case, it just blows people's minds, because this applicant was approached. He was asked to be a confidential informant. He refused, he declined to do that. And this was after his oath ceremony had already been scheduled. And after he declined to be a confidential informant, the next day, oath ceremony descheduled, Homeland Security investigations come to his home, and he was arrested supposedly for lying on his application because, as I mentioned earlier, he did not understand that the question that says, have you ever been arrested, detained, or cited? He did not know that a traffic ticket, which is the colloquial term that most of us use, that a ticket is a citation. Therefore, he had been cited. And so while he had received a traffic ticket for things as innocuous as parking too close to a fire hydrant or not having a taxi cab manifest in the car with you, things that unimportant, because he was cited for them, the government came back, withdrew his oath ceremony, detained him for over a year and a half, and all of that had to be clawed back just to proceed in his application process. Did you have any specifics on those that you wanted to go over, Kate? Or?
Yeah, and actually that one they criminally charged him. So he
Yes.
was in criminal custody for about criminal and immigration custody about 30 months total. Like they had him switching around, and they had him in some of the worst places. And they were sneaky of where they detained him.
That's
for
what I was
deportation.
about to say.
So
they placed him where it was to their benefit. Go ahead.
Yeah, he was on appeal in the Fourth Circuit. They placed him in detention in the Fifth Circuit, where you did not have to have a final conviction. So yeah, they were extremely methodical and sneaky about that one. But that's kind of what we see. But I think one more slide, and then I think yeah.
This is all retaliatory, right? Frankly,
oh yeah,
this is all contextual.
Yeah. I mean, some of them have a basis in fact, but the way that the government is culturally incompetent, and almost intentionally. Yeah, the one that was on there about that she talked about, that was where his child was born. I'm very respectful when I go to USCIS, and interviews almost have never lasted more than an hour and a half. That one lasted 2 days. We're on appeal now. That one lasted 2 days. I have never raised my voice at a government official so much, and my coworkers have enjoyed watching the videos of those. So
thoroughly enjoy. So we've kind of talked about the specifics for the immigration piece, but there are other implications, other areas that kind of bleed outside of immigration. And so this slide here really just kind of tells you some of those instances that would be more relevant to some of the other departments within MLFA. And so I just kind of want to list them here, and we have the website information if you wanted more information for those areas. But like, if you're having employment discrimination that's sort of based on some of these religious things, if you're getting watch lists or no-fly issues, our civil department handles many of those cases, and that is well within their area of expertise. On the criminal side, when you're looking at like the terrorism enhancement and sentencing, material support of terrorist activities, and we're talking like the criminal prosecution, not just as it relates to the immigration application itself. If you're getting multiple FBI interviews, things like that, our criminal department handles that on a regular basis. So the information is there. And then our nonprofit department handles, like if you're needing to have for your organization, your nonprofit organization, if you're wanting a compliance assessment or a compliance remediation. So you've had an assessment and there are some areas where you could sort of beef it up, get it more. So if there were previously deficiencies that you need to address, they can sort of help you identify those areas and then work through getting those addressed. Currently, right now, for that department, we're focusing on Texas and Indiana, but hopefully we will be expanding that later. So again, the link is there to contact those departments directly if you have additional questions.
I would say we've got some good informational videos too. So
Lots
there's
of videos,
some good content on that.
Yes.
So, all right.
You're so muted.
Yeah.
You're good.
Yeah, thank you. All right. Well, let's start up the questions. There was a lot shared there, so perhaps somebody has a question. Just I would say just unmute yourself and feel free to ask your question, and we'll go from there. Anyone?
We promise we won't turn you over to the FBI for asking questions.
I had a question. You were talking about the designated watch list of the peers. You had mentioned that somebody could be a friend of the U.S. government, act on behalf of the U.S. government at the direction of the U.S. government, only for that designation turns later on. And when they apply for an immigration benefit, it would be harmful to them because the destination changed. Have you ever seen that happen?
So that actually is one of our cases that we were specifically talking about. And we've got a couple others that are kind of kicking around right now. But this was somebody who was from Afghanistan and fought with one of the Mujahideen in the against the Taliban and against the Soviets, and came to the U.S. and received asylum. And then that was like a year before, maybe a year and a half before 9/11. 9/11 happened, Patriot Act was passed, Real ID Act was passed. So there were new areas of the law that the government then retroactively applied to that same conduct that did not disqualify him for asylum. We tried to untangle it, and unfortunately, he had a situation and he passed away before we could really finish his case. But we do believe that some of our arguments to USCIS made a difference in the policy that came out in June of 2022 regarding the evacuees that happened out of Afghanistan, because they included one of the exceptions to those inadmissibilities under TRIG for people who fought between 1979 and 1992 against the Soviets and the Taliban. So I feel like if nothing else, somebody else maybe will benefit from his case, even though we were not able to get him the final resolution we were hoping for.
Person is just in limbo because while their final is approved and they're not going to be placing deportation proceedings, they're inadmissible, so they'll never become a permanent resident.
Right. The government specifically said within all the court proceedings, we're not going to deport him. Which is another frustration. Like, they have these people, and that's the other limbo they put people in. Like, they will deny somebody at U.S. Citizenship and Immigration Services, but then never put them in deportation proceedings. We have a couple of those that since I've been here 4.5 years, the government has never initiated those, and we can do nothing. That is a government initiated discretionary process. And so they can do nothing. I mean, other than putting their money back to USCIS and getting the same result. But they don't get to have that reviewed by what's supposed to be a neutral arbiter.
There's nothing that an appellate body can review.
Can you repeat it, Sunny?
Is there anything that an appellate body can review?
At this point, they are stuck because they had their I-485s, which are the adjustment of status to lawful permanent residence, denied. And it is, they were actually denied a while back. So they could apply again, but going to court on those cases is extremely hard because of some of the Supreme Court precedents that has been set in the last 4 years that says those are very discretionary. And if it's a decision based on discretion, that the government does not, you don't get a chance to review that. One of the cases actually has some missteps that they made as well. So there is probably a slight justification on the government's part, but there are exceptions and waivers that he could apply for were he to be allowed to get into immigration court.
You got that last piece that I was about to add. It looks like Sana has a question.
Hi. Are there any organizations, like, does AILA almost like, I don't know if this is the right way to phrase it, but like lobby for any changes to be made? Like, how can we, I know this is a loaded question, how can we fix the process in the future, or like what steps can be taken to raise concerns as immigration attorneys, you know, to fix things?
I think that AILA lobbies for a lot of things, and there are a lot of problems. And so this isn't one of their top tier problems, but I think the way that we fix it is we continue to challenge the government, we continue to take it to court, we continue to make noise. And that is, I guess, one benefit that I feel like we had out of the case, that they did come out with an exception that included the policy that we were arguing against. That sometimes we get our wins at the administrative level and it's a quiet win, but it still helps other immigrants. And AILA, I think it would have to start affecting more broadly before that was really something they put their advocacy efforts into. They do a lot for humanitarian efforts, and yeah, it's just, I think, not a big enough fish for them to fry.
And I would add to that, like the American Immigration Council, there's a lot of lobbying that they do. They file a lot of amicus briefs, and they're working on several class actions at the moment where you see the same thing happening multiple times. And so that's another organization that absolutely is working to try to fix this issue in the immigration system. But as Kate said, it just depends on what it is. It has to be one of those big fish, as you would say, to garner that sort of attention.
And I think, unfortunately, it's one of the rules we have to live by as attorneys is bad facts make bad law. And so some of these cases have kind of slippery facts that you don't necessarily want to be the test case. And some of the ones that have come out in the last 2 or 3 years have been really great. And I've loved that people have challenged them, because we've had some big wins in the immigration world. And some of them, I wish that attorney would have just sat down. So yeah, but I think that we continue to do that, but litigation is an expensive prospect, and that is in some ways, the only way that you're going to make noise in the immigration world is if you're willing to step out of the admin process and get into the federal courts with the right case.
I would say, to piggyback on that, Kate and I have discussed this a lot, and we've seen this a lot, is that sometimes filing the suit, if it's a good one, that you're not taking bad facts, but if you're just filing it and getting it into court, having that go through enough times, even if they moot it out before you get a decision from the court, having them have to answer it starts to make waves. You can get some progress in that particular client's case, and then they start to make policy changes to avoid more of those types of cases coming forward. We've sort of had a lot of discussion about that recently, which is sort of, again, what we were saying with the case that Kate spoke about a moment ago. We did file for cert, Supreme Court cert on that case. While we didn't get it, the policy changes that came out seemed almost directly related. So it was like, we can tell that there was we see this case, this is going to come up again, let's address this issue. But again, that started by at least getting it into the court, even if you don't proceed through the entire process.
One of the things I would say too is that AILA and AIC have been really good at FOIAs, because what the government hates more than anything in litigation is discovery. They are trying to keep their process in all aspects private, and so that they continue to have the power. And so even if we can't maybe do big lobbying or big advocacy, asking for documents that are available because they should be an open record has been a fantastic way that AILA and AIC and some of the other groups of organizations have beaten back some really nasty policies, just maybe not in the trig area right now. But lawsuits are what gave us the information of what the CART program really is. And there's actually a memo from 2008 that actually outlines it, that I believe it was either a group of law firms and organizations and CARE or ACLU got out. And so that's been very helpful, because we see that what their method is.
Found that just filing the FOIA by itself sometimes gets you the results that you want, or just maybe filing an appeal on a FOIA will get you the result that you want. So sometimes those little steps.
Kate and I recently have, on a lot of our cases, started, so in our intake process when we're trying to decide if we're going to take a case. Now we have started doing FOIAs on a lot of those just to sort of get that background information. And lo and behold, after we filed that G28 on that FOIA, just on the FOIA, interviews start getting set and hearings start getting set just from asking those questions. And we've seen that that there's been an uptick in that recently.
Pro se applicants get treated terribly in all aspects of immigration, and they don't realize the tools that are available to them to be able to better go into their cases with the information that the government thinks that they have and the ability to actually correct it.
All right. Well, we're at 53. Time for one more question. If anybody has another question. Well, then this looks like a good point where we can wrap this up. Okay, there's the contact information. Kate, Frankie, thank you so much for all your hard work and spending time with us today. Thank everyone. I want to thank everyone for joining us today, and thank the DFW Muslim Bar Association as well for hosting. And I guess with that, so long, everyone. Oh, here's the CLE information.
Yeah,
right?
this is important.
Yeah. All right, so
You should
yeah,
be
you
able
go
to
ahead and
scan the
screenshot
QR
that.
code.
Yeah.
Yeah.
Yeah, it'll
To
take
get
you
right
to
to
the,
the-
yeah, it'll take you to the Texas Bar page. And with that, you can actually make the submission. So we enjoyed having you all here, and definitely if you want more information, we're available to do additional CLEs, or not even CLEs, webinars for you or your organization. And we do really appreciate the host organization here allowing us this platform.
Thank you.
Anybody needs the code after today's session, just let me know, give me and then I'll send it your way.
And then I'll go ahead and read the course code out, just because I know some people aren't looking. If you're listening on the phone, you may be able to at least hear it. But it is 174217502. So hopefully that helps everyone. Thank you again for joining us.
And I'm guessing that the DFW Bar Association will have a way for this recording to be available for those who might want to share it.
All right. So long, everyone.
Bye.
Bye.
Assalamu alaikum.